Brij Bhushan Sharan Singh has walked free after one of India's most closely watched sexual harassment trials. 6 women wrestlers stepped forward with allegations that triggered nationwide protests, a Supreme Court intervention, and years of legal proceedings. Today, the Rouse Avenue Court acquitted him, holding that the prosecution had failed to prove the charges beyond reasonable doubt. But for the complainants, this verdict marks not closure, but another chapter in a fight they say is far from over. Let's begin with a timeline of what really transpired as far as this entire case is concerned. It's a legal battle that unfolded over more than 3 years and remained at the center of a national debate. What began as allegations by some of India's most celebrated wrestlers soon escalated into nationwide protests, demands for accountability and intervention by the Supreme Court to ensure the registration of an FIR. The case then moved through multiple stages, from police investigations and the filing of a charge sheet to the framing of charges by the trial court. Along the way, the separate POSCO case, also involving a minor complainant, was closed after the court accepted the police's closure report. And today, the long legal journey culminated with the Rouse Avenue Court acquitting Brij Bhushan Sharan Singh and co-accused Vinod Tomar, holding that the prosecution had failed to prove the charges beyond reasonable doubt. Alongside the main sexual harassment case, Brij Bhushan Sharan Singh also faced a separate POSCO case, as we mentioned, based on allegations made by a minor wrestler. That case followed a different legal trajectory. It began with the registration of the POSCO FIR in April 2023, following the wrestler's plea before the Supreme Court. Over the next few months, Delhi police recorded witness statements and carried out its investigation before filing a closure report, stating that it had found no corroborative evidence to support the allegations. The minor complainant later informed the court that she did not oppose the closure, while her father stated that the complaint had been made in anger. In May 2025, a Delhi court accepted the police's closure report. But before we get to the verdict, let's revisit the charges that were leveled against Brij Bhushan Sharan Singh. One was Section 506 of the IPC, which is criminal intimidation. There was also Section 354 of the IPC, which is outraging the modesty of a woman. There's also Section 354A of the IPC, which is sexual harassment, Section 354D of the IPC, which is stalking as well. Let's also take you through some of the excerpts as far as the complainant's version is concerned. This is what the excerpts have mentioned, because clearly, of course, the one charge is that Singh placed his hand on me and groped me in a restaurant. Let's also get to the next charge which has gone. Vinesh has pledged to fight on, said that they've taken on immense courage to register the FIR. This is a post by Vinesh Fogart following the acquittal that has come in from the court, going on to say that they are deeply saddened by the court's verdict. They further said that girls were intimidated into withdrawing complaints. This is the charge that has been made by Vinesh Fogart as well as several of the others. Let's also take a look at what really is the issue as far as the entire case as a verdict dominates the headlines. Supreme Court has now sent out, we've seen the NGA who has come out and given a very powerful message to courts across the country. It is a first of its kind move and has adopted comprehensive guidelines asking judges to abandon victim-shaming language and patriarchal stereotypes while dealing with sexual offense cases. All of this happening on the same day when the Brij Bhushan Sharan Singh verdict has come out. But let's take a look at what really has been done in terms of urging the courts to use gender-sensitive, survivor-centric terminology and reminding the judiciary that justice must be delivered with compassion, dignity, and empathy, not prejudice. Let's take a look at some of the expressions Supreme Court wants judges to leave behind and language that it wants them to adopt instead. Earlier, body of woman as a playground as a phase. Now, violated bodily autonomy of the victim is the terminology that has been suggested. Earlier, terms such as victimization and soul destroyed would be used. The suggestion now is that the survivor experienced trauma that has to be given. Earlier, self-respecting woman now should be termed woman that could be used without any adjective is what's being suggested. Satisfy his illicit lust should now be replaced with committed sexual assault. Earlier, she was enticed away, should be now accused, lured the victim by gaining her trust. Earlier, outraged her modesty, now violation of bodily autonomy is what has been suggested. The acquittal of Brij Bhushan Sharan Singh in this high-profile case where several top wrestlers had made allegations against Mr. Brij Bhushan Sharan Singh is out. To talk about this particular verdict and what are the legal implications from here on, I have with me Mr. Rajiv Mohan, who's a lawyer for Brij Bhushan Sharan Singh. Thank you so much for joining us, sir. Now, the allegations against Mr. Brij Bhushan were extremely serious. How are you looking at today's acquittal? Because does it prove that those allegations are false, or only that the prosecution was unable to prove those in a court of law?
In a criminal trial, this issue cannot be exactly decided as to whether the allegations are false or not. The issue which are being decided during the criminal trial is that whether prosecution was able to prove the case or not.
Right.
Because it is not in the domain of the court to go into that aspect, that whether the allegations are false or true. The simple aspect is whether prosecution succeeded in proving the case or not. That is the core issue.
Right. Because Vinesh Fogart has alleged that the system and the government tried to shield Mr. Brij Bhushan. Does today's verdict demolish that allegation in your view?
Certainly, because there was no aspect of any shielding. It was an open trial. All the victims represented by the lawyers, they appeared before the court. Before the judge, they gave their statement during examination in chief. I was given the opportunity to cross-examine the witness. And during that cross-examination, glaring contradictions, inconsistencies, post-incident conduct, and improbability, these aspects were surfaced during the cross-examination. And these aspects made their statement highly unbelievable.
Right. Now, Vinesh Fogart has said that the wrestlers will appeal in a high court as far as this verdict is concerned. Are you confident that this acquittal will stand judicial scrutiny in appellate courts as well?
Certainly, because lower court is the basic platform where the case from both the sides is being built up, and the appellate court and the superior courts always reappreciate the evidence brought on the record. So there was no inherent lacuna in the appreciation. Rather, during the cross-examination, what answer they had given, that was appreciated with the record. Because if record is showing that the statement is contradicting their own record, certainly the court will come to the conclusion that the version is appearing to be not believable.
Right. We also have seen in this entire trial that there are testimonies that have come in from at least 32 prosecution witnesses. Now, despite that, the court has acquitted your client. So, according to you, what was the turning point in the defense's case that convinced the court to, not consider as seriously the kind of or give weightage to these 32 witnesses' statements?
Because out of these 32 witnesses, the statement of 6 victims were recorded. There were about 6 witnesses who were examined by the prosecution to support the claim of the victims, and rest were the official witnesses or police witnesses. Now, so far as the statement of victims are concerned, it was a case where the victim, before coming to the police or the authority, made their allegation public by sitting on the dharna. No explanation was tendered as to for long, 1 year, 2 year, 4 year. They remained silent for not reporting the matter to any authority. So far as the main complainant is concerned, she made an email before sitting on the dharna that no offense was committed with me. So once all these contradictions are appearing on the record that for long 2 or 3 years there is no allegation, then when you start the protest, simultaneously you are making a mail saying that no offense was committed with me, then you are filing an affidavit before the oversight committee where you are saying that place of incident was different. Then when you come to lodge the complaint, in the complaint the place and year, those were changed. So when all these aspects were pointed out towards cross-examination, and these contradictions and inconsistencies that made the statement unbelievable.
Okay, you're saying so the witness statements were self-contradictory, and that is what made that is what convinced the court not to consider them.
Not to consider, and the post-incident conduct that also played an important role in deciding the case.
Right. Now, this is a case that was not just fought, as far as the legal opinion or the opinion of the courts is concerned, but this was also a case that had a lot of public opinion, a lot of public perception. Do you think that this judgment will alter the public perception? Because the entire perception was, here is a leader, somebody who's a powerful politician, the head of a powerful sports federation, who is misusing his position and his power to exploit young women athletes. Do you think that the perception will now change?
No, because the public perception is not based upon the true fact. Public perception is based upon what the allegations are being made and what the hue and cry can be made from those allegations. But the trial is not based upon their perceptions. Trial is based upon only two facts: whether the fact proved, not proved, or disproved.
Right.
So, because the purpose of trial is to travel from the allegations, then presumption, then proving of the case. So, if the case remained unproved or not proved, certainly the court will award the acquittal, because these are the aspects which have nothing to do with the public perception. Public perception is simply on the basis of the allegation. And public on their own assess the allegations with the position of the person. But during the trial, it will not help.
Now, given the seriousness of these charges, Mr. Mohan, one question that comes to mind is, why would so many players stake their reputations, stake their careers, and come out and make these statements as far as Mr. Brij Bhushan Sharan Singh is? If you're saying that these are fabricated claims, why do you think they would be doing so?
So this is the question which at least I can't answer, because I'm strict on the evidence which they have brought on the record. And from the record, if it is appearing, for example, the prominent complainant, she is saying that first sexual assault was committed in the year 2015 at Turkey. And when she is lodging the complaint, she is saying that no, it was not 15, it was 16, but was of Mongolia. So these are the aspects which may compel anyone to say that these allegations are somehow motivated, or up to some extent there was not any truth in those allegations. Because otherwise, because we all experience in our common day-to-day life that sexual harassment allegations are not like that. Once I felt ill, or so I'm not remembering as to what happened on that day. These are the allegations from both the sides, either for the side of the accused or from the side of victim. These are the allegations which a female will never tolerate or will never forget these allegations.
The law allows them to complain later. Time is or limitations do not strictly apply as they do in other aspects.
It is not the issue of delay. Say for example, this Me Too complaint, Me Too this movement. Now, so many complaints were filed where victim came and saying that about 10 years ago, this offense was occurred with me, and now I'm making this complaint for this. But in those cases, the victim is straightforward, came to the authority. Here, there was a difference. First of all, there was no allegation. Then, when they sat on the dharna, no allegation. When dharna proceeded, all of a sudden, on 19th of February, on 18th of February, there were the allegations were started coming up. Then filing of the affidavit having some different facts. Then protest. Then petition before Honorable Supreme Court. Simultaneously complaint before police authorities. Then this FIR. So this aspect also simultaneously appreciated by the court.
Right. Do you think there's merit in the argument that another agency needs to investigate this particular case and not the Delhi police?
Delhi police is competent enough to investigate such type of cases.
No, I think the question being referred to is that the Delhi police has already given him a clean sheet in the POSCO case, the earlier trial that has happened.
Because that POSCO case was not dealt by me, so I'm not in a position to make any comment on that.
You believe the police has been fair in its probe?
Police was fair now.
Right. All right, Mr. Rajiv Mohan, I'd like to thank you so much for taking the time out and speaking to us, sir.
Thank you. Thank you.
Joining us for more is Senior Advocate of the Supreme Court, Mr. Dushan Dave. Thanks for speaking to Times Now, Mr. Dave. Let me begin by asking you, the law appears to have taken its course in this particular case. There were complaints made, FIRs filed, charge sheets filed, charges framed, and now an acquittal. Do you believe that justice has been done in the Brij Bhushan Sharan Singh case?
Well, it's very difficult to know because we don't know in great detail what was the prosecution case, what was the evidence which was placed. But the fact of the matter is that serious allegations were made by not one individual but a group of young athletes against Mr. Bhushan. And that raised a very serious question on the functioning of our sports bodies. Besides that, if the police found that, yes, there was a prima facie case, the police, investigated and filed a very exhaustive charge sheet. Now, if once exhaustive charge sheet is filed, then one presupposes that there was, a prima facie case or there was a case for the court to have really seriously gone into and decided. It's not very clear as to what really has weighed because I have not seen the judgment which has been passed by the learned judge. But there is something which is really troublesome in this country, and that is this, that more often than not, you see that the rich and the powerful get away from the judicial clutches. And this is a matter of serious concern for us as a nation. Even otherwise, the percentage of conviction in this country is extremely low. It's not more than 30 to 40%. So more than 50% cases are filed by police either wrongly or after filing them, the police is unable to bring home the charge. What happens here is that the investigation may have been done well, but we don't know what the public prosecutor placed before the judge, how he argued it, and what is it that the judge really understood. So at every stage, the level of seriousness which is required in serious cases like this, because, whatever one may say, I'm not here on, to say whether Mr. Bhushan is guilty or not. But if serious charges have been leveled against him by a group of, women athletes, the judge should have looked at the case very differently. The prosecution should have been far more serious. These are cases where prosecution should bring a special counsel who really can, bring home the charge. So I think there is a level of, I would say, there is not much seriousness because, Mr. Bhushan perhaps is a very leading public figure, whatever may be the reason. But it's definitely a sad story so far as India is concerned.
Right. Now, these alleged incidents of sexual harassment are said to have, according to the complainants themselves, the victims themselves, taken place between 2016 and 2019. Now, the locations include the Wrestling Federation of India office at Singh's residence, also overseas as per reports. But clearly, if the acquittal is to be believed, these accusations do not have legs to stand on. The prosecution, the defense has constantly been pointing out to the contradictions in the statements that has been made. What do you think has gone wrong, if at all, the way this case was handled or pursued?
See, nobody can believe that these girls brought the charges falsely. You have to really, you have to see what is happening in the country today. I mean, even today, women are facing problems in our country. We are a feudal society, and therefore it's not uncommon for people in power. I have seen it in Supreme Court. I mean, people in power have abused their position even in courts. So it's not unbelievable that these charges were, yes, they did not have courage, perhaps, and they spoke of much later, which is something which is a matter of, something to ponder about. But, very few women in this country really have the courage to bring home, point out these charges because the society looks down upon them. And secondly, more often than not, these charges are never brought home. Nobody is really found guilty. So I I feel that we as a nation need to introspect as to what we want to do in these kind of cases. Should we not have, I mean, frankly, a case like this should have been heard by a lady judge because she understands the sensitivities of, problems which are being faced by women. And
Correct.
that would really made a much of a difference. Prosecutor could have been a lady prosecutor, a special prosecutor. So I think these are things which we should really introspect as a nation. I mean, I'm not for a moment suggesting Mr. Bhushan is guilty, but I am definitely of the view that the rich and the powerful really get away from the judicial system.
There's one more aspect to what you're saying. In Vinesh Phogat's own statement, she says, and she has alleged that the system and the government tried to shield Brij Bhushan. Do you believe this to be true?
Well, it's not surprising. I mean, politicians always scratch each other's back, and they always try and protect each other. I mean, we know what is happening in this country. I mean, everything is shoved under the carpet, unfortunately. And I mean, this is a matter where, government should have been far more serious because, both Mr. Prime Minister and Mr. Amit Shah are very serious about these issues. And I'm therefore, really surprised that they have not put their foot down to ensure that justice is done. Whatever may be, ultimately, he may not be guilty and he may be, absolutely, innocent. But at least the government should have made special efforts to, have this case handled.
Right. Now, in this particular case, interestingly, there were 32 prosecution witnesses. Of course, I'm not suggesting that there's any guarantee that the number of witnesses strengthens the case or weakens the case against the accused. But the implication of such a verdict is that there was some kind of large-scale fabrication because, 32 witnesses' statements have been clearly ignored by the court due to inherent contradictions, etc. The question then becomes, is such a large-scale fabrication, is it possible?
Well, if it is, then the police should be prosecuted for bringing home a false charge. The Criminal Procedure Code provides such a provision. You cannot charge anybody falsely. So I think the police officers, including the senior most police officers who were, looking after this investigation and who were behind the charge sheet, should be held responsible. So but I feel that, look, perhaps the judge has been overwhelmed by the fact that it was a case which was brought after a long period of time or whatever. I have not seen the judgment, but perhaps the judge needed sensitivity in a case like this.
But when it comes to such cases of sexual harassment, isn't there a lot of leeway given to the victims in terms of, usual legal limitations, etc., that is put out? And in your own experience as a lawyer, do you feel that the evidence, at least what was coming out before us, was pretty strong in terms of its evidentiary value?
I won't be able to make a comment without seeing the evidence. But I do feel, I've seen, over 48 years of my practice, that generally, women are at the receiving end in the judicial system. And when they bring home the charge of sexual harassment or rape, the judges and the prosecution both are not supportive to them. In fact, they are looked down upon. And that is a matter of serious concern. And that's why I've always felt that we need more women judges in the judicial system. If your population is almost 50% women, and if judiciary has less than 5% women judges, then you can understand what's happening in this country. So we need overhauling the system. We need many things to be done. And these cases really give us an opportunity to introspect and try and reform ourselves as fast as possible.
Right. What are your observations about how Delhi police, which investigated this case, approached the matter? In a previous case, there was another case that Mr. Brij Bhushan Sharan Singh, for instance, had faced, and that was a POSCO charge. In that, he had virtually been given a clean sheet as well by the investigating agency in this case.
Well, less said about the police in this country. I mean, frankly, police is too much under political influence now. And it is very difficult for us to really find police, working independently and efficiently, because that's a big challenge. That's a larger question. We need reforms in the police system, but I think the politicians control the police system completely. And therefore, it is very difficult for us now to, really come across cases where police any agency, for example, it's not just police, but, investigating agencies like CBI, ED, income tax, every agency is today under political pressure, and they act as per, the wishes of their masters, which is a sad commentary on rule of law, because rule of law is basic structure of the constitution. and a democracy. And therefore, if you don't have a strong rule of law, then I think we are going to face very serious problems.
Right. Now, these wrestlers have vowed to appeal. Do you think an appeal will hold, particularly before an appellate court like the High Court? Are there any precedents of this happening in the past?
Well, I won't be able to comment on that because I have not seen judgment, nor have I seen, the charge sheet or the evidence in support of prosecution case. But I have no doubt about the fact that if it is filed, the High Court will definitely look at it very seriously.
All right. Mr. Dave, thank you so much for taking the time out and explaining this to our viewers.
Thank you.